In our previous lecture, we have seen how the various domestic democratic institutions have responded to the Armed Forces Special Powers Act, AFSPA. In this lecture, we shall be looking at how the United Nations respond to AFSPA. One of the stated purposes of the United Nations is to achieve international cooperation in promoting and encouraging the respect of human rights for fundamental freedoms for all without distinction of race, sex, language, or religion. To translate this objective into action, a Commission of Human Rights was set up in 1946. One of the first tasks of the Commission was to draw up a declaration and a covenant on human rights. Accordingly, the Universal Declaration of Human Rights, UDHR, was adopted in 1948. And instead of one, two covenants, namely the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, ICCPR, were adopted in 1966. These three basic documents are known collectively as the International Bill of Rights. Over and above the two covenants, the United Nations have come out with several instruments dealing with different aspects of human rights, such as the International Convention on Elimination of Racial Discrimination, the International Convention on Elimination of all forms of discrimination against women, the International Convention on Rights of the Child. Covenants and conventions are legally binding treaties, and the states can become a party to it or stay away from it. But once they become a party, they commit themselves to submit periodic reports on how they are implementing the instrument in their jurisdiction. An independent committee of experts examines the report and engages with the representative of the state party in a constructive dialogue. Thereafter, the committee issues its collective views on the positive aspects of human rights situation in the state party, factors and difficulties impeding the application of the covenant, principal subjects of concerns, and suggestions and recommendations. India had signed most of the major human rights treaties of the United Nations, and most of these committees have expressed serious concern over Armed Forces Special Powers Act. India ratified the International Covenant on Civil and Political Rights in 1979. Its first report was submitted and examined in 1984, the second report in 1991, and the third report in 1997. The fourth report is due since 31st December 2001. The Human Rights Committee, consisting of 18 experts from a wide range of legal systems, supervised the implementation of this covenant. While examining the second report in 1991, several committee members found AFSPA to contravene some of the most important rights guaranteed by the covenant, including Article 2, the state obligation to give effect to the rights recognized by this covenant. Article 4, the state of emergency and derogation from some of the rights obligation. Article 6, right to life. Article 9, right to liberty and security of person. Article 14, right to fair trial. The issue of AFSPA came prominently again while examining the third report in July 1997. At the end of the session, the committee came out with the following written observations and recommendations. The committee remained concerned at the continuing reliance on special powers under the legislation such as the Armed Forces Special Powers Act in areas declared to be disturbed and at serious human rights violations, in particular with respect to Article 6, right to life, Article 7, right not to be tortured, Article 9, right to liberty and security of person, and Article 14, right to fair trial of the covenant, committed by security and armed forces acting under the law, as well as paramilitary and insurgent groups. The committee, noting that the examination of the constitutionality of the Armed Forces Special Powers Act, long pending before the Supreme Court, is due to be heard in August 1997, hopes that the provisions will also be examined for their compatibility with the Covenant. In this respect, bearing in mind the provisions of Article 1, 19 and 25 of the Covenant, the committee endorses the view of the National Human Rights Commission that the problems in these areas affected by terrorism and armed insurgency are essentially political in character, and that the approach to resolving these problems must also essentially be political and emphasizes that terrorism should be fought with means that are compatible with the Covenant. The Supreme Court, while upholding the constitutional validity of AFSPA in its judgment of November 1997, completely ignored this request from the UN Human Rights Committee to examine the Covenant compatibility of AFSPA. It may be noted that ICCPR allows states to derogate from certain provisions of the Covenant, but only if exceptional circumstances exist which justify the state's inability to comply with the obligation. Only if the strict requirements for such derogation laid down in the Covenant are met does the Covenant permit them. The state wishing to derogate also have to follow a number of procedural steps. The requirements are laid down in Article 4 of the Covenant, paragraph 1 of which reads in part, quote, "In time of public emergency which threatens the life of the nation and the existence of which is officially proclaimed, the state parties to the present Covenant may take measures derogating from their obligation under the present Covenant to the extent strictly required by the exigency of the situation. But no derogation is ever allowed from certain rights as specified in Article 4 Clause 2 of the Covenant. These non-derogable rights include the right to life, Article 6, right not to be tortured, Article 7, freedom from slavery, Article 8, right not to be imprisoned for failing to meet the contractual obligation, Article 11, right not to be subjected to retributive punishment, Article 15, right to recognition of a person before the law, Article 16, right to freedom of thought, conscience and religion, Article 18. The formalities required to derogate from these rights provided in the Covenant are specified in Article 4, paragraph 3. The state wishing to derogate has to inform other state parties to the Covenant through the Secretary General of the United Nations for any derogation made for the reasons why the state is doing so. The United Nations need to be singularly informed of the termination of any derogation. To date, India has not made any formal derogation from any rights guaranteed in this Covenant. It is thus obliged to observe all its provisions fully. The UN Human Rights Committee, therefore, in its concluding observation, stated as follows: "The committee regrets that some part of India have remained subject to declaration as disturbed area for many years. For example, Armed Forces Special Powers Act has been applied throughout Manipur since 1980 and in some areas of that state much longer, and that in these areas the state party is in fact using emergency powers without resorting to Article 4, paragraph number 3 of the Covenant. Therefore, the committee recommends that the application of these emergency powers be closely monitored so as to ensure the strict compliance with the provisions of the Covenant." The Convention on Elimination of All Forms of Discrimination Against Women was adopted by the General Assembly in 1979. India ratified the convention in July 1993. The Committee on Elimination of Discrimination Against Women monitors the implementation of CEDAW. The committee, after examining India's first report in January 2000, wrote in its principal areas of concern and recommendation that it is concerned that women are exposed to risk of high levels of violence, rape, sexual harassment, humiliation and torture in areas where there are armed insurrections. The committee recommends a review of the Prevention of Terrorism legislation and the Armed Forces Special Powers Act in consultation with Human Rights Commission of India, the National Commission of Women and civil society, so that special powers given to the security forces do not prevent the investigation and prosecution of acts of violence against women in conflict areas and during detention and arrest. The committee recommends that women be given an opportunity to make their contribution to peaceful conflict resolutions. The committee also recommends that the introduction of gender sensitization and human rights program of police, the security forces and medical professionals in addition to the program already undertaken. The second and third periodic review of India took place in 2007, and the committee continued to express serious concerns in the following words. The committee is concerned that the state party has not taken adequate steps to implement the recommendations in regard to some of the concerns raised by the committee's previous concluding comments adopted in 2000. The committee is also concerned that it has not been provided with any information on the report of the committee established to review the Armed Forces Special Powers Act in response to the previous concluding comments. The committee reiterates the concern that recommendations in the concluding comments adopted in 2000 and urged the state party to proceed without delay with their implementation. The committee requests the state party to provide information on the steps being taken to abolish or reform the Armed Forces Special Powers Act and to ensure that investigation and prosecution of acts of violence against women by the military is in disturbed areas and during detention and arrest is not impeded. The International Convention on Elimination of All Forms of Racial Discrimination, CERT, is one of the earliest human rights convention to be proclaimed by the UN General Assembly in 20 November 1963. India took keen interest and ratified the convention on 3rd December 1968 and submitted its first report in 1970. CERT committee monitors the implementation of CERT. In the last review of the 15th to 19th report in February 2007, the CERT committee had a copy of the Union Home Ministry's own unpublished report of the Committee to Review the Armed Forces Special Powers Act 1958. On perusal of this report, the CERT committee was convinced that AFSPA is an instrument of discrimination against the ethnically distinct people of northeastern states. The CERT concluding observation stated as the committee notes with concern that the state party has not implemented the recommendation of the Committee to Review the Armed Forces Special Powers Act to repeal the act under which members of the armed forces are not prosecuted unless such prosecution is authorized by the central government and have wide powers to search and arrest suspects without warrant and to use force against persons or properties in Manipur and other northeastern states which are inhabited by tribal people. The committee urged the state party to repeal the Armed Forces Special Powers Act and to replace it, within quotes, by a more humane act. In accordance with the recommendation contained in the 2005 report of the above review committee set up by the Ministry of Home Affairs, it also requests the state party to release the report. The Government of India has not repealed Armed Forces Special Powers Act till date, and the CERT committee is actively perusing the matter with the government. India ratified the International Covenant on Economic, Social and Cultural Rights along with ICCPR. The first report was discussed in 1990 and the joint second to fifth report was examined only in 2008. This committee has also lended its voice by stating the state party should consider repealing Armed Forces Special Powers Act in its recommendation in paragraph 50. Thematic procedures are independent experts mandated by the Human Rights Council to report and advise the Council on specific themes of human rights. The special procedures has become a vital part of the Council, and more thematic mandates are created covering all aspects of human rights: civil, political, economic, social and cultural. There are at least 36 thematic mandates in the United Nations Human Rights Council today. The Special Rapporteur undertakes country visit and on individual cases and concerns of broader structural nature by sending communication to the states in which they bring allegations of violations to their attention. On 14th of September 2011, India extended a standing invitation to all these thematic procedures. By a standing invitation, India joins a group of 93 countries who have announced that they will always accept requests to visit from all the special procedures. In the last 3 years, from 2011 to 2013, 3 special rapporteurs visited India, and all of them have recommended the repeal of AFSPA. Mrs. Margaret Sakagia, the UN Special Rapporteur on Situation of Human Rights Defenders, made an official visit to India in 2011 and submitted her report to the Council in 2012. The report stated that the Special Rapporteur was deeply disturbed by the large number of cases brought to her attention during the course of her visit by defenders who claimed to have been targeted by the police and security forces under counter-terrorism legislation such as the Armed Forces Special Powers Act. The Special Rapporteur was told that these laws are being arbitrarily applied, particularly but not solely in areas where internal armed conflict or severe civil unrest exists, to provide legal grounds for a number of human rights violations against the defenders. On the section on defenders affected by security legislation and militarization, she wrote, quote, "At the time of the visit, Manipur was reportedly the state worst affected by militarization, with more than half a dozen human rights organizations being branded as terrorists due to their self-determination advocacy work. Since 2000, Irom Sharmila, who has been on a hunger strike to demand the repeal of Armed Forces Special Powers Act, has been forcibly detained and force-fed in a hospital in Imphal. For 10 years, the National Human Rights Commission reportedly never visited Sharmila despite repeated requests by defenders. Special Rapporteur thanked Sharmila for her letter read by her brother during her visit to Guwahati. The report recommends inter alia that the Armed Forces Special Powers Act should be repealed. other security legislation should also be reviewed in the light of international human rights standards. Special Rapporteur on Summary, Arbitrary and Extrajudicial Execution, Professor Christoph Hans, conducted his official mission to India in March 2012. And his report was presented in the 23rd session of the Human Rights Council in Geneva in 2013. The report highlighted AFSPA in the context of fake encounters and noted that the existence of this practice was recently acknowledged in the courts. The report dedicated a whole section on analysis of Armed Forces Special Powers Act. It states, "The Supreme Court of India ruled, however, in 1997 that Armed Forces Special Powers Act did not violate the Constitution. The Special Rapporteur is unclear about how the Supreme Court reached such a conclusion." The Special Rapporteur, however, notes that in the same case, the Supreme Court declared as binding the list of do's and don'ts elaborated by the armed forces and contained a series of specifications on the matter of applying AFSPA in practice. Although the list contained more precise guidelines on the use of lethal force under AFSPA, the Special Rapporteur believes that they still fail to bring AFSPA in compliance with the international standards in this regard. In the Special Rapporteur's view, the power granted under AFSPA are in reality broader than that allowed under a state of emergency, as the right to life may effectively be suspended under the Act, and the safeguards applicable in the state of emergency are absent. Moreover, the widespread deployment of military creates an environment in which the exception becomes the rule, and the use of lethal force is seen as the primary response to conflict. This situation is also difficult to reconcile in the long term with India's insistence that it is not engaged in any internal armed conflict. The Special Rapporteur is therefore of the opinion that retaining a law such as Armed Forces Special Powers Act runs counter to the principles of democracy and human rights. Its repeal will bring domestic laws more in line with international standards and send a message that the Government of India is committed to respect the rights of all peoples in the country. The report recommends that India should repeal or at least radically amend AFSPA and the Jammu and Kashmir Armed Forces Special Powers Act, with the aim of ensuring that the legislation regarding the use of force by the armed forces provided for the respect of the principle of proportionality and the necessity in all instances as stipulated under the international human rights law. It should also remove all legal barriers for the criminal prosecution of members of the armed forces. While waiting for the necessary amendments or repeal of AFSPA, it should be ensured that the status of disturbed area under AFSPA is subjected to regular review, for example, every 6 months, and a justified decision is made on its further extensions. The Special Rapporteur on Violence Against Women, its causes and consequences, Mrs. Rasida Manju, visited India in April-May 2013. She will be presenting her report to the Council in June 2014. At the end of her mission, she enumerated the rights violated by AFSPA when seen from the perspective of violence against women. She stated that on the issue of conflict-related sexual violence, it is crucial to acknowledge that these violations are occurring at the hands of both state and non-state and went on to say that Armed Forces Special Powers Act and the Armed Forces Special Powers Act Jammu and Kashmir has mostly resulted in impunity for human rights violations. Broadly, according to the information received, the law protects the armed forces from effective prosecution in non-military courts for human rights violation committed against civilian women, among others, and it allows for the overriding of due process rights. Furthermore, in testimonies received, it was clear that the interpretation and implementation of these acts is eroding fundamental rights and freedoms, including freedom of movement, association and peaceful assembly, safety and security, dignity and bodily integrity rights for women in Jammu and Kashmir and in the northeastern states. Unfortunately, in the interest of the state security, peaceful and legitimate protest often elicit a military response, which is resulting in both a culture of fear and of resistance within these societies. The Council, which has replaced the Commission in 2006, has come out with some novel peer review mechanisms in the United Nations, in which human rights record of all the 193 governments will be periodically reviewed. This is called the Universal Periodic Mechanism. The actual review itself takes place in Geneva in a session of the Working Group on Universal Periodic Review, or the UPR, which is composed of 47 member states of the Council. The review takes the form of a 3.5-hour interactive dialogue between the state under review and the members and the observer states of the Council. A few days after the interactive dialogue, the working group adopts the report of the proceedings. The final outcome document contains the report of the working group and the position of the states under review on the recommendations put forward, is adopted at the following plenary session of the UN Human Rights Council. India's human rights record was reviewed twice under the UPR, first in April 2008 and second in May 2012. In the first cycle, United Kingdom, Canada and Germany raised the issue of Armed Forces Special Powers Act. In the second cycle, Slovakia, Switzerland, France and Spain made the following specific recommendations. Number 1, repeal Armed Forces Special Powers Act or adopt the negotiated amendment to it that would address the accountability of security personnel, the regulation concerning the detention as well as the victim's right to appeal in accordance with international standard. This was Slovakia's recommendation. Number 2, review AFSPA to align it with the obligations under International Covenant on Civil and Political Rights and other international standards. This was Switzerland's recommendation. 3, carry out an annual review of AFSPA aiming to gradually reduce the geographical scope, and this was France's recommendation. 4, guarantee effective access to justice in cases of human rights violation committed by security forces personnel with regard to the use of torture. This was Spain's recommendation. 5, implement effectively judicial proceedings making possible the bringing to justice security forces personnel who have committed human rights violation. Again, this was from France. Unfortunately, however, the government of India did not accept any of these recommendations on AFSPA. It continued to insist that AFSPA was upheld by the Supreme Court and several checks and balances are introduced with strict guidelines when dealing with terrorists and insurgents, and that violations were dealt with swiftly and transparently. Despite all the criticisms by almost all the committees monitoring the major human rights treaties, all the special rapporteurs who have visited the country in the last 3 years, more than half a dozen governments in the UPR process, Government of India continue to ignore the call to repeal Armed Forces Special Powers Act. At this juncture, we can only recall Mrs. Navinathan Pillai, the UN High Commissioner for Human Rights, during her maiden visit to India in 23rd March 2009, where she didn't mince words and spoke straight. She said, India should repeal those dated and colonial era laws that breached contemporary international human rights standards. These ranges from laws which provides the security forces with excessive emergency powers, including the Armed Forces Special Powers Act, to laws that criminalize homosexuality. Such legal vestige of a bygone era are at odds with the vibrant dynamics and the forward thrust of the large sector of India's polity.